position as a chair, are you sure of what you are confessing? That the Senate has substandard? I highly doubt, Chair. And I speak as an ICT expert. Probably what they have supplied cannot roll with our equipment, Mr. Chair. I think let's only settle the matter that let them play the videos from where it can play, but Chair, your confessions, personally, I don't agree with.
Senator Mandako, it's not a question of semantics. They say the test of the eating is in the button. So we are now eating. So we know the test of the technology now is that ours is not working. And the one we're about to use is working. So our button is not good. Proceed.
Thank you, Chair. I'm trusting that the Secretary is now ready to play from our laptop.
Because of that mix-up, we will add you a correction of 10 minutes so that you don't lose your time.
Thank you. Thank you very much, Chair.
It seems that even that one of theirs is not working. Maybe you spoke too early.
It confirms my position, Chair.
I am informed that we have supplied them with the same.
Okay. I think we have a big problem here. They are now saying you speak through the mouse, the mic, and tell us which one you want played. Now they will play it. I don't know what magic they have played.
Thank you. Can we look at KMS29A? KMS29A.
na ntwara boturi yaje muno bo uragwara gite kawira indi na ntwara boturi yaje muno bo uragwara gite kawira indi mwebo karaga bakwendra aria uragwara gite kawira india sa karaga batikwendra atwauga aria airi ngotoke yanto maburwa bamuvara kazo na bakarama nuntu ramba ndire kwaria na ntwara kawira twina barabanga bondo bakwete nuntu boka ngavana baraba kuruta maoni yo support ngavana
Chair, we don't have the translation. I don't know why Council keeps forgetting.
Yes, I'll ask the witness to explain what that particular person is saying.
He is saying, Excellency Governor Kawira were not around to speak, but those that were speaking hail of our governor were around to speak.
Thank you. Can we play the next one? KMS30. KMS30. because of time, we can have that video post. We were unable to translate the noise and the chaos because it doesn't come in any particular language. But the witness can maybe confirm if he knows any of those people appearing in that video, especially the person being hounded out of that forum.
Yes, I know him. That event happened at Mkobo Stadium. For sub-county is Nkwene Mitungo, and the person being beaten by others is the former MCA for Nkwene Ward, Nick Burugo.
Is he a supporter of the governor or not a supporter of the governor, to the best of your knowledge?
He is a very strong supporter of Governor Kawira Mwangaza.
Thank you. To my last line of questioning, the move of this motion has said that he has no personal beef with the governor. Between the move of this motion towards, rather expressed by the move of this motion towards the governor.
Yes, I do.
Yes.
I've seen his scripts before election and after election.
Are you referring to the clip KMS3?
Yes.
Kindly, can we have that clip played? KMS3.
Professor, whatever Kawira Mwangaza. If you cannot manage 63 million, my question to the women rep Meru County, Honorable Bishop, Professor, whatever Kawira Mwangaza. If you cannot manage 63 million NGAV funds, can you manage 12 billion? Do you know how a billion is written? You can't.
Is that the move of this motion, Honorable DMK?
Yes.
Thank you. Was that after or before the elections?
Before the election.
Can we now look at KMS18 after the elections, whether the honorable member has changed their mind on their perception of the governor? KMS18. Thank you. The translation of that video is contained at volume 4, KS18. Mr. Witness, kindly tell us in a summary what is being said in that video and who is uttering those words.
That is the move of motion, this motion, the impeachment motion, Honorable DMK Kawira, saying that governor is a thief. She has stolen money from GAV fund, and she has used the same to do a building at Makutano. And number two, she is wearing a necklace, as much as she is calling a silver bishop. she is not a bishop, she is fake, but a thief. And they are not ready to listen to her or do anything with her because she is a thief.
Thank you. Last, can we play KMS 17? KMS 17.
Irongo very anto against the MCAs, Nano Rongo, Meru. Then I wear a mirror to each on the Gavana Wera, each your Rongo, then to Joe Mario. Was a anti and Renyao, humiliate on Tunde, no Dongoria, and I want to Pelent to each on the Botai, right your Rongo. That would the one Rongo one.
The translation is found at page 108 of volume 2. Who is that speaking?
Is Mwenda Idiri, the Rindo Minority County Assembly of Meru.
The same person who appeared before this Senate to offer evidence?
Yes.
What is he saying?
And whatever he has told the Meru people is not true, is false, only that he was not given time, he could elaborate everything.
Thank you. And while we are still at this particular witness, he appeared before the Senate yesterday and talked of being vilified by the governor in his ward. Were you present during that incident?
Yes, I was.
What date was it?
It was on 24th of October, 2022.
What transpired? Rather, why were you in his ward?
We were on an environmental meeting with the governor. Actually, the governor was distributing some seed to the farmers in the area.
Was the honorable member invited for that meeting?
Yes, he was.
How was he invited?
He was invited through myself and through the acting CEO, acting chief officer, agriculture.
At what time did the member for the county assembly for that ward appear for the meeting?
Immediately after governor and rose to speak, because I was the master of ceremony of that event, and immediately I handed over the microphone to the governor. That's the time I saw him coming.
He testified that he was present throughout, even before the governor made her speech. Is that correct or not correct?
Not correct.
Not correct. So what transpired when he walked in?
He walked in when governor was speaking, and because of that, governor gave him a mic to speak to the people. But governor was still standing because protocol deserves that when governor starts speaking, no one else now can speak in the same meeting.
So did he speak to the crowd after the gracious invitation by the governor?
Yes, he tried to speak, but the crowd was against him. Crowd was telling him that he shouldn't apologize for what he has done to the governor.
Is it the governor who called the crowd to boo him, or it was the crowd that demanded for that apology?
It was the crowd. Actually, the governor was trying to control the crowd because the crowd was saying it's a must that he apologize. At one point, the governor said, I can apologize for him, but the crowd said, no, let him personally apologize for the
Person alleges that he was violently hounded out of the stage. Did you witness any such hounding off stage by the governor?
I did not.
You did not. So in your witness before this Senate, has any of the allegations against the governor been proved based on the facts that you are aware of?
None that has been proved.
None that has been proved. I think that is all for this witness, Honorable Chair. I hope that I have kept time, unless my learned friend has one or two issues to clarify. I believe we still have the extra 10 minutes that you had promised us.
Yeah, precisely. Your time is now up. So I had given you a bonus of 10 minutes. Take advantage of that, Council.
Thank you, Honorable Chair. I'll be very brief. Mr. Witness.
Yes.
I want to clarify a few issues. I think you dealt with everything. There was an indication yesterday that EACC has made a determination on a complaint made against the governor. I want you to confirm whether you are aware of any determination by EACC.
I'm not aware.
There is also an allegation of a violation of the public finance management laws. I would like you to inform this committee. Has the governor prepared any budget?
No.
How are you spending money if any is being spent?
The governor is using the budget that was passed in the previous regime, the budget of the year 2022.
The county assembly?
I'm not aware.
Not aware.
Yeah.
To the best of your knowledge, does the governor have the control of the beginning and the end of the budget cycle or process in a county?
No.
Who are the other entities involved?
The members of the county assembly.
To the best of your knowledge, has the governor ignored any of those institutions in the budget-making process?
No.
No. Another financial impropriety was in respect to Meru Referral Hospital. First of all, tell us, is there any structure that manages that hospital?
Yes.
What's the nature of the structure?
There is an act of the county assembly of Meru that was passed, and now Meru General Hospital is a SAGAS, or a semi-autonomous body, managing its own affairs with a board of directors, a board of management, as the situation that is at Kenyatta National Hospital, the same with other institutions that are within Meru County. But it is managing its own funds and its own budget, its own activities.
Look at our volume 2, the governor's bundle of documents, at page 161 of volume 2. You can see the document there?
Yes.
What's that document?
That is the Meru teaching and referral board and the matters connecting to the bill that I talked about.
And the following page, what is the description?
It is administrative provisions.
At the beginning, is that the county act of county assembly you are referring to?
Yes.
Thank you. Has the governor directed expenditure of any money outside that framework?
No.
Is the governor a player in that hospital?
No.
Does she have any control in that hospital?
No.
There are allegations that have been made of demeaning and vilifying public leaders in Meru County. And they are cited in the charge number B. Some of them you have alluded to. Have you seen the governor vilify any public leader?
No.
How would you describe the interaction between the governor and other public leaders in Meru County?
It is a good working relationship.
There was a ward administrator in one of the markets you visited, and you alluded to earlier on. What's the name of that ward administrator?
The Mwenda. He's called Mwenda, sub-county administrator, Nkwene Mitugo.
In his affidavit, he says he cooperates and coordinates county affairs.
It's true.
How do you describe that working relationship with the governor?
It is good.
Is he also a leader in the county?
No?
A ward administrator who coordinates county affairs. Is he a leader in the county?
Yes, yes.
There were allegations made about the first criminal responsibility attributable to the governor, to the best of your knowledge.
No, they cannot be.
Is there anything else you'd like to explain briefly that you have missed out?
Something small
Yes.
that I need to explain. There is let me call it a confusion, because our governor was a philanthropic even before the election, even before she became the Women Rep Meru County, and she was running a program called Okoa Kana Kameru, Saindia Mtoto wa Meru, and she has been able to have many people that she has been employing using her money to that program, and there is a lot of confusion that those people that she employs in every place are referred to as county government employees, whereas they are not county government employees. They are people that are trying to assist her to run the program that she has been running as an individual, not as the governor of Meru County, including the first gentleman, who is now the head of that team as the ambassador of the Asoras of Meru County.
Thank you very much. The first gentleman, before the governor became a governor or woman rep, you were told that he was a cultural ambassador.
It's true.
Who appointed him the cultural ambassador of Meru County?
I can't remember.
You can't remember.
Yeah.
Does he have any other activities?
Your time is up. 2 more minutes, close up.
Does he have any other activities he has engaged in that promotes the county of Meru's image, the first gentleman, in an independent capacity?
Yes.
Such as?
He has been a musician and as much MC of some functions, and we have also been using him as the MC in our functions before governor was elected in Meru County.
The committee and for cross-examination.
Welcome. Time to cross-examine. Dr. Mudomi, you have 1 hour and a half.
Chair, there is an emerging procedural issue we crave your leave to raise before we begin the cross-examination of the witness. And the issue is as follows.
Go ahead.
The governor has chosen, perfectly within her rights, that she will not give evidence. And whereas that's within her rights, and she can't be faulted for it, we find ourselves at a disadvantage. And the disadvantage is as follows. The governor has had ample time to challenge our case and our evidence, and specifically to challenge the evidence of the mover of the motion. Our problem is, even as she exercises her right not to take to the witness stand, she has filed before you several affidavits, one of them by herself, some of them. By law, those affidavits are part of your record. By law, those affidavits are evidence. The whole essence of an affidavit is that it is sworn evidence in writing. To the extent that these people are not being called to testify and specifically to be cross-examined, we run the distinct disadvantage that whereas the governor's side has had the ample opportunity to challenge all our witnesses by way of cross-examination, we denied an equal opportunity. Chair, you just said what is good for the goose is good for the gander. Now, our problem, Chair, is we can't force persons who are unwilling to testify to take the witness stand. But I also understand, whereas the decision the governor and the deponents of those affidavits have made is perfectly within their rights, the decision they took is not to give evidence in chief. We would want it to be clear from the record that we are making an application to cross-examine the governor and our witnesses on the deposition set out in those affidavits. Of course, Chair, they can still choose. They have already chosen they don't want to give evidence in chief, perfectly within their rights. But if they also choose that they don't want to be cross-examined, and we are making the application under Rule 10 of your rules, that they be called so that we cross-examine them. They are not obliged to accede to that request, Chair, but it should be clear on the record that they are not amenable to be cross-examined, so that in our closing statements, then we'll crave your leave to address you on the implications. Because if that issue is not addressed, you remain with our evidence thoroughly challenged, which is okay, but the evidence taken for gospel truth without the opportunity on our part to show the gaps, to show the contradictions, hopefully some falsehoods, and in short, it will not be a fair trial. This is a trial. The Senate is sitting as a trial chamber. So let them confirm to you. We already have their confirmation that these persons will not testify. But let them also confirm to you for the record whether they also don't want to be cross-examined, so that we close that matter, and then I can proceed with the business at hand.
Would you like to indicate precisely on what it is you would like to cross-examine the governor? Because he has given a lot of evidence. Are you telling the chair that you want to cross-examine her on her affidavit?
On our affidavit, Chair, and our formal response to the case, because she has filed before you a response to the motion. She has also filed before you an affidavit, which is evidence. We are entitled, of course, subject to what you decide, but by law, we are entitled to test that evidence, and every position she has taken in that response and in that affidavit, and it's not just our chair, there are several other people whose affidavits are also on your record. On her, we want to cross-examine her on everything set out in our response, and specifically in her affidavit, together with those other affidavits of other witnesses. But she is the Liberty Chair. I must point out this, and I've said it ad nauseum. She has the liberty to tell you that she is not amenable, because at the end of the day, you cannot force anyone to testify. And even if you do, nothing useful can come from someone you're forcing to speak if they don't want to testify on their own case.
Yes, counsel for the governor, we shall hear you.
Thank you, Chair. We object to that application being made by my learned friend, Dr. Nyankolu. One, for the simple reason that he admits that indeed there is no requirement in law that a governor or any accused person appearing before such a committee can be coerced or forced to testify. That is in the rules, and it would be against her right to fair hearing to compel her to utter even one word against her wish. The rules governing these proceedings, Honorable Chair, require the governor to elect means within which she will appear before this committee. She has done exactly that by indicating that she will be represented by counsel who are on record and have done exactly that. So we cannot offer the governor for cross-examination when she has not tendered any oral evidence before the committee. It will be a prejudice on her part, and we risk being accused of violating her rights to fair hearing. Even in normal criminal proceedings, and have the court infer any inference of our silence. What needs to be done is for the prosecutor of this motion to table evidence. Ours is to challenge and punch holes on that evidence, and that's exactly what we have done. The governor's voice has been heard through our advocates. It would be a violation of our right to put her on this stand to be cross-examined against her wish when she has not offered herself for that exercise. Secondly, the affidavits that are on record were supplied to learned counsel. We did indicate, in compliance with your rules, how many witnesses we intend to rely on. That was not objected to. When we were introducing these affidavits, we did not at any time indicate that we would call this as witnesses, for the simple reason that the witness we've just brought here, we believe is a wholesome witness who is able to cover all the allegations that have been leveled against the governor, having personally witnessed and having personal knowledge of all the issues that are contained in the motion. Those affidavits merely corroborate what the witness has confirmed of events that he attended personally and has personal knowledge of. Those other witnesses would not really be so much useful to this committee because they are only meant to collaborate the evidence on record. But for the record, let me say this. Save for the governor, we are willing for the other witnesses to be summoned by this committee for cross-examination. We have nothing to hide. We are only trying to be considerate on the issues of time, but should this committee feel that there is need for these witnesses to be brought, then we can have them summoned subject to convenience of time. We have no objection. Thank you. He says there is nothing I've left out. That is all, Honorable Chair.
I think then it is clear for purposes of the record, because for us we only wanted...
Order. Relax, completely. You've made your application. Yes, you have invited your colleague to say something.
Honorable Chair, thank you.
Just hold. Proceed, sir.
Honorable Chair, thank you. There are only 3 issues I wanted to raise. I think the application by my learned friend has not been made at the most appropriate time, because in the course of a testimony by our witness, he should have allowed us to complete this witness. He could examine this witness on any issue, because we said this is a wholesome witness who would cover anything and everything. and he demonstrates which evidence this witness was not able to respond to upon cross-examination. At that juncture, he would have every cloud even to demonstrate to this committee which issues he would like clarified, and he would like this committee to benefit from the evidence of any other witness. Then, other issue I would like to emphasize is that when we saw the issues of time and knowing what can happen, we decided to just get one witness. So the governor has planned her case from filing a response and affidavits, as well as fielding a witness who can attest to all those affidavits. The counsel for the county assembly indicates in exact precision that he would like to cross-examine even. It is a pleading or a document signed by the advocates for the governor. So even at that juncture, we'll have a complication whether it's the advocate who proceeds to the start to be cross-examined. That's what we are saying. All matters in the response and all the affidavits. And an affidavit is a repository of oral evidence. The most the county assembly can do is to demonstrate the affidavits and the evidence in those affidavits has not been corroborated and it's not verifiable. And this witness cannot verify that. Or the other witnesses who have also testified by their affidavits cannot verify that affidavit. Once we get to that point, this committee would consider how else can it be able to verify the challenged or the impeached evidence by the governor. And Honorable Chairman, this motion was brought by the county assembly. They have the duty to discharge the burden of proof beyond reasonable doubt before the evidential burden shifts to the county assembly, to the governor. That's my contribution, Chair.
Thank you. I can see a red light there. Yes, Council, you appear for who?
I appear for the County Assembly. My name is Abdikadir Sheikh. Chairman, I would like to, of course, the committee and the chairman are aware.
Kadir, hold your horse. We now know you. Lead Counsel, is it your intention to invite Advocate Abdikadir to address us?
Chair, you can indulge him, but at the risk of not taking too much time, I said all we needed in making this request was confirmation from the governor's side that they are not amenable to have the governor cross-examine. We are not even asking you to make a decision on the matter because they have the right to choose. But that right has certain legal consequences. They are not amenable to have the governor cross-examined on affidavit. And since that's all we wanted to go on record, the matter is resolved. So I can continue if you
Okay, I've heard you.
But you can hear my friend Abdikadir.
I've heard you. Before I invite your colleague to come, are you really being fair to us? Are you attempting to play mind games? You make an application, we listen to it, and before we make a determination, you then make your own determination, and you say that to be reflected in the record. The least, Council, be humble, Council. You are not the only person in the least you can do, you put your case. Your colleagues have responded. Allow me to fall back to my team. They'll make an input. And if their determination agrees with what you want to be the determination, then be it. If it doesn't, then raise hell. Don't play mind games with us. Common sense.
Came out like I'm playing mind games with the Senate. The only reason I said the statement that seems to have caught you the wrong way is I acknowledge the governor has a certain legal right. She can choose not to take. So even as I make my application, I must be cognizant that she has that right. Yes.
Dr. Mudomi, this House has a long history of a tradition of discharging business. Here, mention of a committee or the entire Parliament, that matter ceases being your matter. It becomes the property of the House. So your application has since become the property of this committee. You will bear with us. We make a deliberation and a decision will be made quickly. Yes, Ahmed?
Thank you, Mr. Chairman. In the rules when...
Sorry, Abdikader.
Yes, thank you, Chairman. The rules said once the lawyers on each side were introduced, I thought we had the audience.
Abdikader, I want you to introduce yourself and confirm that you are on the list of advocates on this matter. Once you do that, you'll address us. Please, introduce yourself in full.
My name is Abdikadir Sheikh, appearing with a doctor for the assembly members.
Yes, second part?
Second part.
Are you on the list of advocates?
I think I'm in the list, yes. And when we started the hearing, I was here the first day.
I'm not being harsh. It's just that if you are on the list of advocates, we've been going on from 24th up to now. We've not come up.
I could help you, Chair. Abdikadir joined our team after we had already. But if you check your answer of yesterday, I had already introduced him as part of my team. But he is not in the original list, so that we don't spend time calling.
You introduced him on the Hansard
Yes,
yesterday.
yes.
So, Secretariat, without wasting time, you will confirm on Hansard if Abdikadir is one of the councils. Abdikadir?
Thank you, Chairman. Chairman, I wanted to comment on brief comments made by the Council for the Governor. Of course, the committee and the chairman is aware that this committee is not sitting as an appellate. An impeachment of a governor has got two processes. It starts with the assembly and it comes to the Senate to confirm. Since this is an investigative committee to confirm the allegations, the analogy given by my learned friend, like if it is a strict court, absolutely it's not. So I support the motion by my learned friend that it's only fair. Everybody who can help the committee to give information should do so. The comment I wanted to make about the analogy that they have the right not to say anything. It is different from a court setting. It is investigative. That's all I wanted to say, my chairman.
Your point is made. Colleagues, I now fall back to you. First light, I have seen a light from Sifuna.
Yeah, Chairman, as I understand the rules, if you look at Rule 10, it says the committee may, at the request of the county assembly or the governor, invite or summon any person to appear and give evidence before the committee. So that, in my understanding of that rule, all we need is a request from either the council, from the assembly, or from the governor, that they would want somebody summoned, and you and the committee would have the powers to summon that person. As to whether that person intends to participate in these proceedings or not, Mr. Chair, you will see that under Rule 11, there is the option of the county assembly or the governor choosing not to appear before this committee. Persons under the Constitution have the right to remain silent. My only question to counsel for the governor is, what is silence? I mean, silence does not mean speaking orally only. If you have filed affidavits before a committee such as this or a court of law, that is you speaking. That is not you maintaining silence. And it cannot be fair to the other side that you file affidavits upon which they do not get opportunity to cross-examine. The way to test the veracity of matters that have been set out in an affidavit is through cross-examination. So the question to council would be, what is the committee supposed to do with these affidavits that have been filed by the governor in the absence of opportunity for the assembly to be able to cross-examine that evidence before the committee? Lastly, Mr. Chair, I know my learned colleagues know a rule of evidence concerning documents called the best evidence rule. That in fact, Chair, as long as the higher or superior evidence is in possession of a party or may be reached by the party, no inferior proof will be allowed. My colleagues know what I am talking about. In the hierarchy of witnesses, I know you said that you selected these witnesses having considered the factor of time. I am just wondering, Counsel, in the hierarchy of witnesses, who is the superior witness between your chief of staff and the governor? Who is actually facing those accusations? I would want some answers on those questions so that we can guide the committee on how we proceed. I thank you, Chair.
Chair.
The Senator of Washington Gishu, Senator Mandako.
Yeah, thank you very much, Chair. To follow up on what Senator Sifuna said, Chair, in rule number 24, no person other than 1A, the governor, 2, a person who has been called as a witness by the county assembly or by the governor, or C, a person who is invited or summoned to appear and give evidence, shall give evidence before the Senate. The Chairman, in this case, Chair, the accused is not the Chief of Staff. And in my considered opinion, Chair, it is actually an opportunity for the governor to be cross-examined on affidavit, just to test the veracity of the information that is in the affidavit. And I think it just done.
Thank you. I have seen the light by Senator Esther.
Thank you, Chair. My concern is further to what Senator Sifuna was saying as to whether the witness evidence is sufficient is up to you to determine. But the governor being the wearer of the shoe, surely this would have been a good opportunity. And I thought if she's not going to speak, there should be an equalization mechanism to compensate that. I'm saying this because the mover of this motion was heard orally. Thank you, Chair.
Very well. I have seen my Vice Chair.
Chair, I was also a bit concerned when the Chief of Staff is the one giving evidence for the governor, because if we have any questions directed to the governor, will he be able to answer them on our behalf? I thought it would be better for her to answer the questions just to clear everything and for us all to have clear evidence and to be able to write everything that we need and to hear also from her.
Senator Tobiko.
Chair, I want to put it in another perspective. Chair, as the council for the county assembly said yesterday, this is a quasi-judicial process. You know, a court process, you would have been across the road. This chamber is, the Senate is quasi-judicial because it's also a political process, Chair. And Chair, my feeling is that, of course, the governor could choose to be represented by her councils. But Chair, for the satisfaction of everybody, the prime candidate here is the governor. And Chair, I mean, it would be best if there is a way, even in silence, for the governor to take the stand so that she's not only cross-examined by the councils, but so that we are also availed the opportunity to directly engage the governor, even if it is in silence.
Thank you. The Governor of Mandera.
Thank you very much, Chair.
The former Governor of Mandera and the Senator of Mandera, the current.
Thank you, sir. Thank you, Chairman. Now that an application has been made and our attention drawn to provisions of Rule 10, and considering how the County Assembly matter has been executed yesterday, it will only be fair, and the option not to exercise has been already superseded by fair to us as a Senate and this special committee to be able to interrogate the evidence, and the County Assembly to be able to interrogate the evidence better by the governor availing herself, and the committee has the mandate for that matter. My request is the Chief of Staff, as the key witness for the governor, may not be able to substantively deal with issues to do with position or responsibility of the governor, upon which is in question, and her impeachment is what we are executing today. It is only fair if the request is made that the governor avails herself. And the chair, my request is we deliberate and you give a ruling on the same. Thank you, Chair.
Yes, Senator Tangwa.
Mr. Speaker, as I said yesterday, I'm not a lawyer. So allow me to argue like a layman. Mr. Speaker, all I understand is we have the accuser and the accused.
Chair, it's a matter of procedure. Can the Senator for Kiambu address you as the chair, not Mr. Speaker?
All right, thank you. Chair, Mr. Chair.
Senator Mandago, relax. It is normal to have a slip of the tongue, but in any case, sometimes I can be so imposing that the young Thangwa sees a speaker in me.
Yeah.
Thangwa, can you proceed?
Yeah, probably. So, Mr. Speaker, I'm talking about, all I see is an accuser and the accused. The governor is the accused. The accuser was the mover of the motion. So she must stand on the dock. And the moment we started this hearing, the charges were read, and she pleaded not guilty. So how come now the governor cannot stand on the dock to be cross-examined on what she pleaded not guilty? Mr. Speaker, I remember yesterday, and I'm trying to help the council from the governor's side, because now I've started reading mischief. We were doing well. Everything was going on well. But yesterday, I remember there was a Catholic priest. And Mr. Speaker, he said he was here because of how he felt, because of his feelings. I'm trying to imagine the gentleman standing here is also here because of how he's feeling about the governor. So do you want me to judge the governor from how the gentleman feels? So I urge, and I would want to assist the side of the governor. The governor is accused. And the issue here is more egocentric than constitutional. We would want to hear, we are here to see, maybe we must start judging the governor. That's the way she is. She doesn't talk to people. She doesn't want even to hear. I don't want to do that now, but I'm trying to help the side of the governor. The accused should stand there so that we can ask those questions. She's seen on TV making utterances, roadside declarations, and then you tell us to examine a chief officer who is not even per se a civil servant. It's more of an organizer of a government, the caretaker, I don't know whether you understand what I'm saying. So, Mr. Speaker, for this house to be taken, the governor must stand on the dock.
Thank you. I think the final submission is from the Senator of Lamu.
Thank you, Chair. Chair, I want to agree with other members that it is the governor that the 62 accusations has been leveled against her. And in fact, the governor was elected by the good people of Meru. They are watching. They want to hear how the governor is going to exonerate herself from all the claims that has been leveled against her. So it is in all manner of good faith that we want to demand that the governor stand and tell us what she has so that we can be able to do a proper determination as the committee. Thank you, Chair.
Yes, okay.
I think that I will start with the side of the Governor's Council. Article 50 of the Constitution, of course, is very clear. And I think that the Governor's Council was drawing us to Article 50I. And we respect that. For the purpose of this committee, however, Chair, if I got the Council of the County Assembly right, the Council is not battling with Article 50 of the Constitution. However, the Council wants us to take a note that should we choose as a committee not to have the governor being examined by the Council of the County Assembly, then the Council is being consequences in terms of when they're making their final submission. I think I took a very serious note to that, to the extent that under the standing orders of this particular House, the Senate, I think it is standing order number, it is actually under the third schedule, number 11, Chair, is in congruence with what the legal counsel, or the Council of the County Assembly is talking about. And I'll read it. Where the County Assembly or the governor chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigation without further references to the Assembly or the governor, but the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the Assembly or the governor. My caution, Chair, is that should we leave the leeway for the Council of the County Assembly to make pronouncements after we have finished the proceedings on this particular matter, then that complicates our own investigations. And because of that, I want to finally say that, Chair, if you look at volume 1 of the document submitted by the governor's team, I think it is page 47. The governor concludes by making 66 statements, and that affidavit particularly isn't signed by the governor's council. It is signed, we accept the application by the council so that justice is served for everyone. Thank you, Chair.
Very well. Whereas Council for the County Assembly, your application looked light, but given the interest and the unanimity on the part of the senators in supporting your application, I'm forced to make a reasonable decision. But before I make it, allow me to discharge two things. The first thing, the senator of Migori. allow me to discount your views on Standing Order number 11. If you go back to it, not Standing Order, on the rules of procedure, number 11. Number 11 only applies in the event the governor had refused to appear. She has come. So let that one rest. The second thing I want to discount is to the governor, the governor's council. Council, please address me so that we go and write something which is reasonable. Address me on this. Are you aware that this affidavit, which belongs to no other person other than your client, the governor, are you aware that if we accept it as it is, and the governor does not take the witness stand, are you aware that affidavit? Are you aware that if, having said what she has said here, she took the stand and responded to these questions, it strengthens her case? Are you aware? Please address me before I ask the council to also address me.
Thank you, Honorable Chair, for that question. Indeed, I am aware of those sentiments. And just to discount some of the fears from the honorable members, the governor has no mischief. The governor has nothing to fear. The governor had not refused to tender evidence. It was just because of the way we arranged our defense that we sought to have one key witness that would somehow sum up all the evidence that all the other witnesses would have brought before this Senate, on the justification that this particular witness was personally available and attended all those functions where the governor is accused of uttering certain words and violating the law in the course of making those words. But having heard the sentiments of the committee, we have consulted with our client, and the client has agreed to be cross-examined on the ground of the basis of the affidavit that she has brought before this court. But then we are also begging for time to re-examine and fix any loopholes or punches that might have thrown away during cross-examination. So we are amenable to that request. Thank you.
Thank you.
And before that, Chair, sorry to cut you. So we request that then we have this witness dispensed with after cross-examination and re-examination. Then we can have the governor come in, after which we shall beg for 20 to 30 minutes to prepare the governor, considering that she had not prepared for this particular eventuality. Thank you.
Thank you very much. So that our records, noble men and women, let us conclude this by allowing the governors, the county assembly senator to also address me. I'll speak to the issues you have raised. You address me on the following.
Chair,
on the following.
Yes.
You address me on the following.
Yes, Chair.
On the following. I'm here to tell you what I would like you to add, so that it helps us to look neat and reasonable. I'm drawing your attention to Article 50, Sub-Article 2.
Chair, on a point of order. Chair, point of order. I'm being asked on a humanitarian basis that you allow the witness to sit as we dispense. He's looking like he can exit this proceedings.
He can vamos. In fact, he's the most important person in the room, maybe. So please, witness, you're free to take your seat for the time being. Thank you, the Senator of Nairobi. This is why you are the Senator of Nairobi, the county of everybody. Yes, Council, I want to draw your attention to Article 50, Sub-Article 2L, which I read. This Constitution is alive 24/7, and it is never suspended. What would you do if I declined your request on the strength that the Constitution gives this governor the right in L to refuse, I'm reading, quote, to refuse to give self-incriminating evidence. Address me on that one, then I'll discharge what you have applied for, Council for Governor, and we proceed.
Chair, the rule against self-incrimination is a rule that governs criminal proceedings. The proceedings before the Senate are neither criminal nor civil. This position, and my colleagues can confirm this, has been affirmed in several decisions emanating from this Senate. One of them is the case of
to proceed. These consultations are very useful.
Fair enough, Chair. So I was saying, impeachment proceedings, though quasi-judicial, are not analogous to civil proceedings in the High Court or any other court. Neither are they analogous to criminal proceedings before the ordinary courts, which is to say, the essence of the process we are going through is not to ultimately find the governor of any civil liability or any criminal culpability. And I was therefore telling you that position has been litigated in virtually every impeachment proceeding that has come before this Senate, and the constant decision of the Supreme Court. I'm only mentioning two because they should be in our volume 2 of our BADO. The constant position from the Supreme Court is that those proceedings are neither civil nor criminal, and they should not be treated as forums for attributing civil liability. And I think that dispenses of another issue that has been coming up before you, which is, why hasn't so-and-so complained? Why are you complaining on his behalf? Those decisions, I said, are in the decision about the impeachment of Mike Sonko, who was impeached by this House, and the Supreme Court affirmed that impeachment. The same position, Chair, can be found from another decision of the Supreme Court in a case called Justice Kariuki Nyaga versus Martin Wambora Nyaga, or rather Justice Kariuki Mate versus Martin Wambora Nyaga, and it should, unless I'm mistaken, also be in our volume 2, but at any rate, I am aware, I'm told, Chair, it is at volume 2, at page 69, the case of Martin, that is Supreme Court petition number 32 of 2014. And I just told you the same position is reiterated. So to your specific question, therefore, the governor cannot be heard to say, if I ask her a question in cross-examination, she cannot be heard to tell you, I will refuse to answer that question because I ran the risk of self-incrimination. While still on the matter, Chair, it is basic law, and all my colleagues will agree, that proceedings before a body like yours, a witness says in this chamber, cannot later on be used as the basis for prosecuting them for a criminal offense or for incurring civil liability. That is the whole essence, and it's not just the witness. Even anything any senator says, the reason it is privileged, Chair, is so that the witness will have the absolute comfort to tell you the truth and the whole truth and nothing but the truth without the fear that the answers they give you. From the Supreme Court decision of Sonko Chair, the relevant paragraph is at page 158 of volume 2 of our documents. Page 158, and the paragraph is 148. That was just pointed to me. So, Chair, it is not open to any witness in proceedings such as those before you to refuse to answer a question on the ground that the answer to that question, if given, would incriminate them, because they enjoy absolute privilege for utterances made before the Senate. But they have the right, by the article you cited, one of the paragraphs in Article 50, they have the right to refuse to give evidence.
Thank you, Counsel. I'm glad and happy that you have addressed me. Members, we have a witness who is the star witness, and therefore he's going to demand for a lot of attention from all of you. It will take quite a bit of time. So if I allow that we conclude his case, then we shall require to, we want to break to make a decision on this one, then we'll require too many projects, we'll waste too much time. So I want to request, Counsel for the Governor, you kill two birds with one stone. We're going to break. The decision concerning this is being made now. And then during that time, you do what you would have done in the second breakout.
Chair.
So what is the decision?
Chair, just a minute.
Yes.
I don't understand the necessity of a break to make a decision.
No, I'm making a decision now. I'm making the decision now. Yeah. The decision we want to make was going to be difficult and maybe academic if the position of the governor was that she was not taking the stand. But because she has agreed to take the stand, we congratulate her for being cooperative and look forward to her on the witness stand. For now, I want to request that we adjourn. We give everybody 1 hour. During that 1 hour, you grab a bite, and during that 1 hour, prepare your governor for the forthcoming interventions. Thank you, members.
Adjournment. The committee with the two parties are taking a break. This should serve as a lunch break, at the same time a 1 hour break before they come back for the next proceeding. We understand that once they come back, the governor of Meru County, Kawira Mwangaza, will be taking the witness stand. Of course, this is after an applicant retreats to make a report and table it before the whole house. So we are taking a break until 4 when the committee will be back. Until then, I hand you over back to Broadcasting House for normal programming. See you later.